Hi, I'm Paul Trudelle,
And I'm Kira Domratchev.
and you're listening to Hall and Estates, and this is episode number 590. How are you today, Kira?
I'm good. How are you, Paul?
Very good, thanks. Today we're going to speak about one of my favorite topics, which is compliance with the due execution requirements when executing a will and substantial compliance. This is a case out of BC that we're going to be talking about. It's in the matter of the estate of Beat George Hubschi, Hubschi, and it deals with a will that didn't quite comply with the requirements of the will's legislation in British Columbia, and there was an application brought to prove or have the will admitted to probate notwithstanding that non-compliance.
It's a very interesting case, and it's interesting because, we often discuss British Columbia statute versus Ontario statute where we don't really have substantial compliance. So something like this
Wouldn't fly in Ontario.
Never.
No. In Ontario, there's strict requirements with respect to the execution of the will. It needs to be signed by the testator. It needs to be signed in the presence of two witnesses who also signed in the presence of the testator. And if you don't comply with any aspect of that test, the will, even though it's clear that it's the last intentions of the deceased, won't be admitted to probate.
That's right.
Now, this case, I think, remedies that problem and is probably a fair result ultimately, and I guess we can debate another time as to whether this is a good thing or a bad thing, but maybe we'll talk a bit about the circumstances that led to the will and what constituted the will and why the court found the document, we can call it that the deceased left, why the court found that to be a valid will.
Yeah. The facts of this case are actually quite interesting. The deceased was born in 1961 and died in June 2017 after a short illness. His birth mother gave him up, and so he spent pretty much his entire life with a foster family.
Right. I think he came to this foster family at age 3.
Exactly.
And stayed with the same foster family throughout his life.
Yeah.
Now, if the family never adopted the deceased,
one of the issues too.
And if there was an adoption, then this wouldn't be necessary. He would have died intestate. Here, I guess, so that we will finish speaking about his background in Vancouver and what would happen if the will wasn't found to be valid.
Yeah, so he spent his entire life with his foster family, and you're right, he was never adopted, but he pretty much grew up in the household. He was treated equally as the rest of the children. I believe there were, 1, 2, 3, 4, 5 Stack children. That was their last name, Stack. Importantly, when the mom passed away in 2011, he was left an equal share of her estate. So he was treated as a child throughout. He was very close with them. He never talked about his birth mother. There was no connection to his birth mother or her family. And those are all things that the court sort of considered. And so he died with no children, no spouse. He had no will that would fit the requirements of a will, because the requirements of a will in British Columbia are the formal requirements are similar in the sense that it's, it has to be witnessed by 2 individuals. And so that didn't fit into, he didn't have a will that would fit into that.
Now, if he died without a will, his estate would have not gone to his foster siblings. It would have gone to his next of kin. And in this case, his next of kin were an aunt in Switzerland and an aunt in Switzerland. He also had a niece in Switzerland.
Yeah.
He had no connection or any communication with them whatsoever throughout their lifetime. But they were served with the application to prove substantial compliance with the will. They didn't appear or make any claim to the estate.
Yeah.
So I think that's an important factor as well.
That made it easier for sure, because if they opposed it, then who knows what the result would have been. Right. But basically the issue here, and why this is so interesting, is there was no will, but he had a computer file. It was a Word document called Budget for 2017. And there was a statement there that said, get a will made out at some point, a 5-way asset split for remaining brother and sisters, Greg and Annette, his foster siblings, or Trevor, as executor. So this was really interesting because it literally says get a will.
Just get a will. It's not
made out
quite a will. It's not signed. It's not witnessed. There's no information as to who would have prepared this, although the evidence was that this was prepared by the deceased on his computer. He was housebound at the time. He prepared it shortly before his death. On the day of his death, the file was accessed by the deceased, presumably because no one else had access to it, but he didn't make any changes.
Yeah.
And the court felt that that confirmed his understanding or intentions with respect to what he wanted to do with his estate.
Yeah. And the short illness, the fact that he got sick and so quickly thereafter, he discovered his medical problems in the spring of 2017. He had surgery and discharged on May 25th, 2017, and then died just 22 days later. So he was at home. And so I think based on the court's decision, it seems as though they took into account the fact that he couldn't really leave the house because he was in pain and he was otherwise indisposed, and the fact that he accessed it on the day was used as an idea. So the court used the Section 58 of the British Columbia Act, which is a curative provision. We don't have that in Ontario. And a record that, could be proven to be a will. It includes data that is recorded or stored electronically, can be read by a person, and is capable of reproduction in a visible form.
Right.
That's basically the provision that they relied on to show that this was indeed a will.
And then the court looked at a number of other cases out of BC and other jurisdictions where there was a handwritten note that wasn't signed, and whether that would be a will or not. There's a couple of cases out of Australia where in one case a text message was accepted as being a valid will. Cases like that, I think the court here, the overriding concern was that the long-standing relationship he had with his foster siblings, the way the family treated him as a child, and he treated them as being his family. The next of kin who would take on an intestacy were so distant and removed from the deceased that the court wasn't troubled by making this decision.
And there was specifically a provision that said had he been adopted, his birth family would not be entitled. So it would, on an intestacy, would pass to his new family, so to speak. Right. So I think that this just shows the importance of, going through the formalities, so to speak, that people don't really consider to be important, because I'm sure that, they didn't really care about the formalities of it. Clearly, they treated him as a child.
He shared in the mother's estate. They celebrated all birthdays and holidays together. It was a very close relationship. It might have been a different case if they didn't have that close relationship, but perhaps not. I think here, though, the court expressly states that the court wasn't surprised by the dispositions that he made in his note. If the note said it would all go to someone else or a stranger, the court may be a little more reluctant to accept this document as a will. But here, the court felt that the document, the note on his computer, was consistent with what the court felt should happen in this case.
Yeah.
So it's a good illustration of the applicability of the Wills, Estates, and Successions Act out of BC. That's something to think about with respect to Ontario. It wouldn't happen here. Should we consider making amendments to allow for this to, I think when applied properly, these curative provisions can cure injustices that result from, a witness not being present or turning their back at the time or signing later, or where, it's clear that the deceased wanted something to happen with his or her estate, and it just doesn't due to a technicality.
No, I agree. I think that there are certain circumstances. This is a glaring set of circumstances that shows why, curative provisions may be helpful. I think certainly the concern in Ontario may be that, it'll increase litigation.
Right.
And people will bring more applications, thinking that their particular circumstances fall within the curative provisions.
I think that's a concern. But I think the courts in BC and other jurisdictions have provided a safeguard for that. They do require strong evidence with respect to whether these are, in fact, the last true intentions of the deceased.
Yeah. And I mean, they've certainly shown an example that it works.
Right. Yes. And it worked here, I think. Well, thanks, Kira. And until next time, we want to hear from you. If you can send us an email at webmaster@hollandhall.com and visit our blogs. I discussed this case in my blog earlier this year or last year. Thanks for watching.